welcome to today's class. Today's class is on the proper way to create a contract, to modify the contract, and to cancel the contract. We're not going to talk about the forms in a broad way. We're going to really focus just on the forms relative to contract creation, modification, and cancellation. So this is not a class on the forms themselves. It's more on a class on using the forms to, again, effectively create a contract, modify a contract, or cancel a contract, and do it in a way where you don't get in trouble or get your client in trouble. All right. As always, if you have any questions about this class or anything real estate related, don't hesitate to reach out to me. Give me a call, send me an email. I promise you I will respond and help you in any way I can. Also, of course, I want to remind you that if you have questions, Larry can also lend assistance, as of course Mary at Remax All Pro. But I'm happy to help anyone if they have any questions at all. So let's jump right into today's class. Today we are going to talk about the purchase contract, how to effectively create it or how it is created, how to effectively modify it, and how to effectively cancel it if you need to cancel it. And again, with the goal not to get yourself or your client in any kind of trouble. So the purchase contract, how is a purchase contract created? The correct way to modify a purchase contract, the correct way to cancel a purchase contract and cancel escrow, and how to handle backup offers. How is a purchase contract created? All right, this is sort of overview in general, and I'll give you a couple of specifics as we go along. To form a legally binding contract in the state of California, the parties must have capacity. The parties meaning the people who are contracting with each other. Capacity means they have to know what they're doing. They have to be of sound mind, and they have to be cognizant of exactly what they're getting themselves involved in. They don't have to understand the contract, don't misunderstand that, but they can't be confused in general about their status as far as their mental capacity. You know, in plain English, what I'm talking about is they can't be suffering from dementia. They can't be suffering from duress. They can't be functioning drunk. If I remember once I listed a property, as I took the listing, as I got further along in my listing, I realized the guy was drunk. So knowing this, I went back to the condo. Actually, I went back to his house. I met him at his condo. I went back to his house the next day and had to kind of politely explain to him, I think you were a little inebriated, like to re-execute the contract, because I did not have a legal contract because the gentleman truly didn't have capacity when he signed it. Okay, the parties must act voluntarily. They have to voluntarily agree. They can't be under duress. Now, they can be under stress. There's a difference between stress and duress. Duress is when somebody is threatened, for example. That would be duress. Stress would be you can't make your payments, the bank is foreclosing, you've lost your job, and you need to do probably a short sale, and your life's sort of coming apart. That would be more likely stress, but not duress. There's no undue threat to you. The bank's not illegally threatening you. They're just telling you you're not making payments and you're suffering consequences. So the parties have to voluntarily agree to the contract. The contract must have a lawful purpose. That's pretty straightforward. A contract to perform an illegal act cannot be enforced. So if somebody gave a contract to someone to, sell them heroin, for example. I think Car Legal used that as an example on one webinar I listened to. That could not be enforced. You couldn't enforce that. Why? Because the sale of heroin in the state of California, I think throughout the U.S., is illegal. So the contract's got to have a lawful purpose. And then finally, there must be mutual consideration. Now, that's a very frequently misunderstood concept. Consideration is not just money. Consideration often is money, but consideration can also be the agreement to perform an act. Consideration can be the agreement not to perform an act. So I can offer consideration to a buyer not canceling if they agree to, whatever it is I'm asking them to do. If I had the right to cancel and I said, okay, I won't cancel, but you have to do A, B, and C, they agree to perform A, B, and C. Mutual consideration occurred. Why? Because I agreed not to cancel. That's an act. And they agreed to do A, B, and C. So that's the parts of a legally binding contract. Now, in general, stress the word general. Contracts can be written, of course. They can be verbal. A verbal contract can be enforced. They can even be implied if people act like they have a contract, even though there is no contract, written contract or verbal contract, but they act like a contract, that can be enforced. That's often in commerce. A vendor will imply they're providing you a service or a product and you pay for it. There could be a contract issue raised there. Now, in real estate, in the state of California, contracts must, I stress the word must, be in writing. Any purchase contract of any kind for real property must be in writing. Any agreement to lease a property for 1 year or more must be in writing. So that is covered by the statute of frauds. It's a fraud to sell a property with in the state of California with a verbal agreement. So have to be in writing and signed by the parties bound by the contract. So the buyer and the seller must both sign the contract or their legal surrogate. And I'll cover that in a moment. Now, requirements to create a legally binding RPA. The RPA discusses this itself. You have to have a buyer signature, obviously, and that's pretty straightforward. The buyer agent writes an offer and the buyer signs it. If you receive an offer as a listing agent not signed by a buyer, you do not have a legally binding RPA, even if you accept it. So buyer signature, step one. A seller signature, step two. Acceptance, and I like to say capital A acceptance. I'm going to discuss acceptance in a minute. Acceptance is sometimes misunderstood. Many of you on this call, I think, understand acceptance very well. Sometimes the best learning is when you're reminded what you already know. So hopefully this will reinforce what you do understand. For some, you might not really realize what acceptance really entails, and we're going to talk about that in a second. And then number four, this acceptance, this capital A acceptance, must be within the time specified in any offer. Any offer to transfer the title to real estate property, real property, which is real estate, must have a time frame allowed or indicated. It can't be open-ended. So listing contracts have to have a expiration date. Purchase contracts have to have a close of escrow, either date or time-specific event. It can't be fluid, if you will. It's got to be very specific. Okay, what is capital A acceptance? In order to have a binding RPA, there's got to be this acceptance. And again, it's a little more than what some people realize. Acceptance is a two-step process. There are two events that have to occur for acceptance of a real estate contract to occur. The first event is what I call the small a acceptance of the offer by the accepting party. That is indicated by their signature. Now, offering party and agreeing party or receiving party can be a little confusing because an RPA offer, the offering party is the buyer. When the seller counters the offer, The seller now is the offering party. They are offering their counter. And the buyer is the receiving party. So hopefully that sort of makes sense to you, and then you can follow along with this definition. Acceptance of the offer by the accepting party. So if a RPA is accepted by the seller without a counter, well, then the accepting party is in fact the seller, and the seller signs the RPA. If the seller if the seller counters the RPA, now the offering party of the counter, which includes the underlying RPA, the offering party is now the seller, and the buyer, if they agree to the counter, the buyer becomes the accepting party. And then it switches again if the buyer sends a counter offer to the seller's counter. So you can see how that goes back and forth. So the first part of acceptance is acceptance by the accepting party of the offer made by the offering party. And that's indicated by a signature on whatever the offer form is. So I don't mean just RPA. It could be a counter offer. It could be a repair request. And you don't have real acceptance or enforceable acceptance without part two. Part two is the personal receipt of the accepting party's acceptance, their signature on the document usually, by the offering party. So in an RPA, the way that would work without a counter is if the buyer writes an offer that the seller accepts, then the seller is the accepting party. They've signed accepting the offer, but we don't have a transaction yet. We don't have a deal, as I like to say, until the seller returns the acceptance, the seller's acceptance, back to the buyer. It must be personally received by the buyer or his designated agent for that to occur. If you had a counter offer, so the buyer makes an offer, the seller counters it, the buyer accepts the counter. So now the buyer is the accepting party. They sign the counter. You don't have a deal yet until the buyer delivers their acceptance of the seller's counter back to the seller who was the offering party. And that must be by personal receipt or the seller's authorized agent, which would be the listing agent. Hopefully that makes sense, but this is very, very important, especially in situations we're in now, where there's a very hot market and offers are flying around and people are claiming they're into a contract and they're not into a contract. This is also very important, this concept, when you are going to withdraw typically a counter offer. A seller makes a counter offer and wants to withdraw it. I'll talk to that in detail. But hopefully you understand this slide here. And if not, give me a call and I'll walk you through it one-on-one. Okay, buyer and seller signatures. A lot of confusion about this. So I want to take this opportunity to clarify this. Both the buyer and the seller must sign the purchase agreement. Now, the holder of a bona fide power of attorney has the authority to sign the principal's name. So a person who holds a power of attorney for a seller could, in fact, sign the seller's name so that the seller did, in fact, sign the purchase agreement. Although the seller didn't physically, the seller authorized the holder of the power of attorney, they're often called the attorney in fact, to sign the seller's name to the contract. I don't like the phrase for the seller because that confuses you a little bit about what constitutes a valid signature when a power of attorney is involved, and I'll explain that in a minute. So they're not signing for the seller, they're actually signing the seller's name because they've been given authority to do that with this bona fide power of attorney. I'll explain that in a moment. Okay. Now, interestingly enough, an agent cannot sign for a principal unless they have authorization to do so. So can an agent forge their principal's name on a document? Believe it or not, the answer is yes, if the principal says it's okay. and that a permission must be in writing. Now, I don't want you to focus on that too much because we don't allow that at RE/MAX, neither RE/MAX United or All Pro. You can never sign for your principal. If you think you have to, you think your principal wants to give you authority, we don't allow our agents to hold power of attorneys on real estate that our agents or our brokerage are involved in selling or buying. So although an agent can sign the principal's name, we don't allow that. They would have to go get someone else and give them a power of attorney. So I just want to point that out to you, because other brokerages, other agents may in fact do that. And of course, if the agent signs their principal's name and, basically forges their principal's name to the document, it's not a criminal act if they have written permission to do so. We would want a copy of that. And so call me or Larry or Mary if you're in that kind of situation. In general, you don't ever do it, of course. Now, how does a power of attorney signature work? Some of you understand this usually power of attorneys understand this if they're attorneys. If another relative holds a power of attorney, they often don't do it. And the way a power of attorney signs the document is strictly held by the courts. They hold a very strict standard. And if this is not done correctly, the court often invalidates the document. So if the power of attorney signature is involved for either the buyer or the seller, first, the signature, and it's not really the principal signing, but it's the principal's name. So if I give Diane a power of attorney, because Diane and I both own our house, but I don't want to, I'm too busy, putting together classes and helping agents with their transactional problems. So Diane, you take care of selling the house, and I'll give you a power of attorney to sign my name to any documents you need to execute. So if that were the case, Diane holding the power of attorney would first sign Walt Klein, any place I'm supposed to sign. Number one, you sign the signature, but it's not really my signature. It's my name, but I didn't do it. Diane did it. So it won't look like my signature. It'll look like Diane signed it, but it'll say Walt Klein as if I did. Okay, so the signature of the principal signed by the holder of the power of attorney. Next, the signature of the holder of the power of attorney. In my little example, after Diane would sign Walt Klein to a document, she would then sign Diane Klein right next to or underneath my name. And then C, the indication of the authority of her signing my name. So she would indicate either power of attorney by power of attorney or attorney in fact. So that 3-step process in that specific order must be done, or courts will invalidate documents. Courts have actually invalidated documents where the power of attorney signed his name first and then signed the principal's, quote, signature. The power of attorney signed it, but he signed the principal's name to the document second. They invalidated that contract. Why? It wasn't in the proper order. So this is very critical. I'll send this out. I'll have give this presentation to Lindsay. I need to do a few things to it because of the way it's structured, but you'll have this so you can review it. Okay. Now, trustee signatures. Courts are not nearly as strict with trustee signatures, but there's a common mistake made when trusts are involved in real estate transactions, and I'll talk about that in a minute. So if a trustee, an individual is a trustee of a trust holding title to a property or wants to buy the property, the trustee would sign the trustee's name, and then he would indicate his authority to sign for the trust. And so the phrase trustee is generally used. So, if Diane held the sole trustee of a property that we owned in a trust, Diane would sign Diane Klein, trustee. Simple as that. Now, Signing the name of the trust is not a valid signature. So if we had the Klein family trust that owned the property and Diane was selling the property as the trustee and she signed the Klein family trust to the document, it would not be a valid signature and the document could be voided because a human being didn't sign it. In general, a human signs everything. Trusts don't sign anything because they don't have hands. They can't pick up a pen. And so we have to identify who signed it. The name of the trustee is the name you appear. Now, here's a little quirk in zip forms. For seller, put the name of the trustee, then a comma, and then trustee after it as the seller, even if the property's held the title in the trust. The seller is still the trustee. That is legally correct. And here's the beauty. If you put the name of the trust as the seller, as the owner of the property, that trust name will appear on every place where the seller is supposed to sign a document. And that will confuse your clients. That'll sort of induce them to sign Klein Family Trust. So if I were preparing a zip form document, I would put under the owner, seller, Diane Klein, comma, trustee. Now, zip forms will put that Diane Klein, comma, trustee everywhere a seller's supposed to sign. Now, if there are co-trustees, you would have two, of course. All right. Business entity signatures, just like trusts, a human being has to sign for a business entity. A business entity can't sign. It doesn't have hands. It can't pick up a pen. So the signature of the person authorized to sign, and then the title of that person, if appropriate. So that would be how a signature on say, I like to use example Qualcomm. If Qualcomm owned some property and they decided they wanted to sell one of them and they had an offer, if they accepted the offer, they're not going to sign their acceptance Qualcomm. Why? Because Qualcomm's not a human being. A person who's authorized to bind Qualcomm to the sale of that property would be the person who signs their name to the document, and then they would put their title. Now, signing with the name of the business entity is not a valid signature. So, in my little example, Qualcomm on a signature line would not make a valid contract. Now, for signatures of power of attorneys, trustees, and business entities, so anytime these are the folks that are signing your documents, you want to provide a representative capacity signature disclosure and obtain an authority document. So a representative capacity signature disclosure is often misunderstood by agents. It is not an authority document. It is, in fact, a document that protects the signer of these documents. What it does is it declares to anybody who's interested that just because Bob Smith, who owns, the business, and he has authority to sign for his business, but his business is buying the property, he can't sign the business name, whatever his business name is, Bob Smith Inc. Bob Smith Inc., if that's the name of the business, they can't sign that. It can't sign because it doesn't have a hand. So Bob Smith, president or owner of Bob Smith Inc., he'd probably be president if it's Inc., Bob Smith, comma, president of Bob Smith Inc. He can just put president, is what he would sign. Now, an ambitious plaintiff's attorney could see Bob Smith's signature on these documents and attempt to go after Bob Smith personally and his other assets when he was simply the authority person to sign for Bob Smith Inc. So the representative capacity signature addendum actually protects the person who's signing, or gives them a level of protection by informing people, other entities, that just because Bob Smith is signing this document doesn't mean Bob Smith is personally liable. His business is liable. It is not the authority document. In my example, we would have to have a statement, probably signed by Bob Smith, authorizing Bob Smith to bind the company to a real estate transaction. Hope that makes sense to everyone. That get a lot of confusion about representative capacity signature disclosures being authority documents. They're not. We need copies of trusts or the certificate of trust, or we need a copy of a power of attorney for these other entities. All right, let's talk about the residential purchase agreement, but only relative to forming a contract. We're not going to talk about all the 10 pages and all the details that you have to understand to fill out a residential purchase agreement. That's a class all by itself. I know, I think Cheryl probably does classes, or Donnie, I'm not sure who, I apologize, at All Pro. Larry does classes at RE/MAX United on how to properly fill out the RPA and all the forms that go with it. I just want to talk about forming a contract using the RPA, which is usually what most of us are involved in. Okay, I want to look at page 9 in a little bit of detail. On page 9, at the bottom of page 9, is the expiration of the offer, and a couple of important points to take a look at there. Paragraph 31, this offer shall be revoked unless it is signed by the seller, and a copy of that signed offer personally received by the buyer. Remember, I talked about that. That has to be the personal receipt of the seller's acceptance by the buyer, or by the buyer's authorized agent, and that agent's name would go in the blank there, who is authorized to receive the offer on behalf of the buyer by 5 p.m. of the third day after this offer is signed by the buyer. Now, the way you count days always, for just everywhere in the contract, we'll reference it several times, but the way you count days is the day of the event is day 0. So with this offer is delivered to the seller today is day 0. The first day after the day of the event is day 1. So the third day would be 4 days from now, maybe. I mean, if you counted today. That we don't count today in any real estate calendar counting of days. And that's true with everything in this RPA. Notices to perform, demands to close escrow, the close of escrow, 30-day escrow. Today, it's accepted. The offer is accepted today. Today is not day 1 of the 30th day. Weekends and holidays count except if they're the last day of the event. So if at the last day of the event, the third day fell on a Sunday, then the third day would fall into Monday. Okay. You can change the 3 days to 2 days, 1 day. You can change the time frame. You can, and then of course the date. Okay, now also the acceptance, paragraph 32. If you are sending a counter, then you, of course, check that box. All of you understand that pretty well. Either sending a seller counter offer or seller multiple counter offer, whatever is appropriate, and you put the date of the counter in. All right. And of course, if the seller is an entity, then you would include the representative capacity signature disclosure seller. For the benefit of your seller, that really benefits the issuing party. So sometimes I get agents who don't want to send them, not our agents, but from other firms, and I explain to them, that really protects your client. You should send it. Okay, the seller signs it, and then if the seller is accepting, if the buyer is being given a copy of the acceptance, then the confirmation of acceptance would be signed by the buyer's agent. Now, if you're making a counter offer, this should not be signed. Do not initial if you're making a counteroffer. A binding agreement is created when a copy of signed acceptance is personally received by the buyer or buyer's authorized agent. And whether or not it's confirmed by this document, completion of this document is not required to create a binding agreement. It just memorializes personal receipt. Okay, the seller's counter offer. Going to go through that in some detail because that's how a lot of offers are contracts rather are created by the use of a seller and buyer counter offer or a seller's multiple counter offer. So let's look at it in some detail. Of course, the seller is usually going to be countering the purchase agreement, and it's usually going to be counter offer number one. The way you number counteroffers, there's no legally correct way. If you do it wrong, it doesn't necessarily mean you have an invalid contract. In fact, you probably don't, but it causes a lot of confusion. The accepted way to do it, the way I recommend, I think the way we'd like agents to do it is you sequentially number all of your seller counteroffers and you sequentially number all your buyer counteroffers. So you'd have seller counteroffer number one. If the buyer countered the seller's counteroffer, it would be buyer counteroffer number one. Then if the seller countered the buyer's counteroffer, it would be seller counteroffer number two. See, that's right here. So now the buyer sent me a counter offer and I'm going to counter the buyer's counter. So I'm going to number it 2 because it's my second seller counter offer and check this box here. Okay. Now, the terms and conditions of the above referenced document are accepted subject to the following. That's the very first statement on this. This is a critically important statement, especially if you don't understand it. From time to time, even our own agents or even, I won't pick on All Pro, so I'll say they've never made a mistake, but some of our agents have made a mistake because they believe that the seller hasn't signed the RPA yet. So it's not binding, or the wife didn't sign the RPA. It's not binding. But if the seller signs the counteroffer, the husband and wife, they accepted everything up here. The purchase agreement was accepted. We've had multiple over the many years. In fact, this year, we've had a couple of instances, or at the end of last year, we've had a couple of instances where we believe the contract wasn't created because our seller didn't sign the offer, but they did sign the counteroffer. Believe me, the contract is created because of this right here. So don't rely on that to get out of jail. You won't. So keep that in mind. Okay. The paragraphs in the offer that require initials must be initialed by all the parties or they're excluded unless there's some other document that incorporates one of those paragraphs. So you could in your counter say, say the buyer didn't initial liquidated damages and the seller wants it. You could either return the offer and ask the seller to initial that as a part of your counter, or you could write in the counter, buyer agrees to the provision of liquidated damages and agrees to initial the document. So you can incorporate it, but if it's not initialed, liquidated damages and arbitration, they require initials. Mediation does not require initials. It's automatically part of the contract. Without both parties initialing, it's not in the contract. Then, of course, the document where you list all the other terms, there's several blanks, of course, you can do that. All of you are familiar with that. Okay, now the expiration of this counteroffer, remember I told you all real estate contracts have to have a drop dead date. So this counteroffers are the same way. So the seller counteroffer will be revoked if it is not by 5 p.m. On the third day after the day was issued, signed in paragraph 4. Paragraph 4, of course, is signed in after they signed in paragraph 4. So the seller has to have signed this or it's not valid. Signed in paragraph 5 by the buyer accepting it. And of course, the buyer might accept it subject to a counter, and a copy of the signed seller counteroffer personally received by the seller if it is accepted by the buyer. All right. Or if the seller withdraws this at any time prior to acceptance, the CAR form woo. I'll talk about woo in a little bit. The woo is the way you in writing withdraw a counteroffer. You can verbally withdraw a counteroffer. So you send a counteroffer out, and here comes another offer that you want to consider. If that buyer accepts that counteroffer and personally delivers it back to you or your agent, you're locked in. So you want to be sure to withdraw that counteroffer that you sent out. You can do it verbally and then follow up with a woo later. And then, or if the seller accepts another offer prior to the buyer's acceptance of this counter. So that's in there to give the seller some protection, but that can be a little problematic. If you can't prove when the delivery of the buyer's acceptance of your counter and your acceptance of another offer, if you can't prove that the acceptance of a second offer came after the buyer's delivery of their acceptance of your counter offer, you're going to have a problem. This is not something to rely on. Better to withdraw the counter offer and then reissue it as a multiple counter offer if you choose. Okay. Marketing to other buyers. Buyers sometimes don't understand this. Buyers think that once they've got an offer, a counter offer out there, as long as this is all in negotiation, the seller sort of, has to deal with them in order as they come in, so to speak. And that's not true. So the seller has the right to continue to offer the property for sale and to accept any other offer received prior to acceptance of this counter offer by the buyer. Be sure your buyers understand that, because if they take too much time in deciding on the counteroffer, they could lose the property. I'm not recommending you encourage them to make a decision they're not comfortable making. Simply point out that there is always that possibility as they sleep on it. That's especially in this market. Okay, in such an event, the seller is advised to withdraw this counteroffer. It's just what I referenced earlier. So if you're going to, prior to accepting another offer, withdraw this one and then accept the second offer or counter both of them. Okay. The seller, makes the counter offer on the terms and acknowledges receipt of the copy, and the buyer they accept it, possibly subject to the an attached counter offer from the buyer, and then a confirmation of acceptance. Again, not required, but it makes it a little bit easier to document that has happened. Okay. The seller multiple counteroffer, very similar in the top, the same three terms as I discussed before. Again, that accepted word right here. So whether or not they sign the RPA or not doesn't matter, because if they're signing the counteroffer, both parties sign the multiple counteroffer, both sellers, they've effectively agreed to everything in the RPA except for what they're changing in the counteroffer. Okay. The difference in the multiple counteroffer and the single counteroffer, the seller counteroffer versus the seller multiple counteroffer, is that the multiple counteroffer, when the seller makes it and the buyer accepts it, doesn't bind the seller. Unless the buyer has accomplished all of the following things. The seller signs paragraph 5, which is signing this multiple counteroffer. The buyer signs paragraph 7. The buyer accepts the multiple counteroffer. The seller signs paragraph 8, which is selecting the buyer's the buyer's response to this multiple counteroffer. And the buyer receives a copy of the multiple counteroffer with all the signatures, including the signature in paragraph 8. And until all of that is completed, the buyer and the seller have no obligation towards each other or for the purchase or sale of the property. Okay, and again, there's the confirmation, the bottom of the form, which is nice to have, but not necessary to create a binding contract. The buyer's counteroffer is very simple. It's basically mirrors the seller's counteroffer that we reviewed in some detail before, so that's pretty straightforward. The withdrawing of an offer, again, I mistyped withdraw. I apologize. The withdrawal of an offer, you can do that verbally on the phone, and then you follow up with a woo. The top of the form, you discuss the offer that you're withdrawing. You identify it. The second part of paragraph 2 is withdrawing it. The buyer and the seller are making the withdrawal and revoking the offer, counter offer. And paragraph next, confirmation of receipt of this withdrawal of offer is nice to have. Okay, the correct way to modify a contract. I just want to make this statement. A very wise agent, I won't embarrass her, but Virginia once told me her favorite quote is, "Everything is great until it's not." So I think that quote, I use that quote quite a bit since I've heard it. And one of the places it comes into play often is when a buyer and the seller are verbally getting along, agreeing to stuff. The seller doesn't want to make all of the repairs. The buyer's kind of concerned about it. And the seller says, "Listen, I got $4,000 worth of patio furniture. How about if I leave that instead?" The buyer says, "Hey, that's a great idea. That's beautiful patio furniture. I'd like that." And so they have this meeting of the minds. The agents exchange emails, and then buyer goes over after close of escrow, patio furniture not there. Well, everything was great. They all agreed patio furniture would cover the seller rather, in lieu of making any repairs for the buyer, and the buyer thought he was getting a good deal. It was great until it's not. And when it wasn't so great was when the buyer showed up and the patio furniture's gone. What's the problem? The contract is very specific, the RPA. Any modification to the contract must be in writing, signed by both parties. I can't tell you how often agents have told me, "Well, I got an email from the agent saying their seller agreed to. Did you put it on an addendum?" No. Guess what? You have nothing. Nothing. So please, please, don't be afraid or don't be reluctant that when there's a meeting of the minds, memorialize it with an addendum. It's simple as that. So the addendum's pretty straightforward. You fill out the top and you discuss what you're going to do. Now, there are some specific addendums as well. The extension of time addendum is one that specifically talks about extending time frames. You can extend the close of escrow. You can extend the removal of contingencies, other extensions. Utilize this whenever the other side is going to give you a little time. "Listen, we can't remove our loan contingency yet, but I think we can do it by Friday." The listing agent says, "Okay, follow up with an ETA." Because tomorrow the listing agent gives you a notice to perform because the seller changed their mind. You've got nothing. "I got this email, Walt." It won't work. It's not signed by the seller. It's not signed by the buyer either, for that matter. So you're stuck. All right. So use an ETA. The modification of the contract. I spent a lot of time working on problems due to modifications of contracts not being memorialized. It's a lot simpler when it's in black and white, signed by both parties, to resolve the issue. The verbal agreements almost always fail. Okay, and of course, it's signed by all the parties. The request for repair and the seller's response are both addendum to the contract. They're very specific about what's being done. And so we've covered that in a previous webinar. You can access it. It's online. Lindsay if you don't know how to find it, I'll put her on the spot. I think she knows how to find it. Okay. Now, there's an interesting new form, and that's the amendment to existing agreement terms. And that form is not to replace an addendum in general. It's more to replace a repair request, believe it or not. It was created to allow for a submission of a proposal of, how about we give you a credit in lieu of making repairs, and then that proposal gets either accepted or rejected by the buyer. And that addendum you don't put in lieu of making repairs, you just put down a dollar amount credit. This form is lender friendly if you keep it lender friendly. An RR, repair request, or a seller's response is not lender friendly. And what I mean by that, most of you know, if the lender thinks that there's repairs to be made, they're going to want the repairs made. They're not going to want a credit issued. So using a repair request for a credit is perfectly fine. You should do it. But then you can also use the AEA to accomplish that as well. Okay. Now, how to cancel a purchase contract and escrow. This is where we get into a lot of trouble. I'm using the royal we here. I don't get in trouble because I don't cancel contracts, but I spent a lot of time getting us out of pickles because contracts weren't properly canceled. And that's especially problematic for the seller, but it's also problematic for the buyer as well. So understand that there is a correct way to cancel a purchase contract and cancel escrow. To cancel a purchase contract for non-performance by the other party, you must first give the party notice. Here's a mistake agents make from time to time. They send the notice of buyer to perform, and attached to it is the cancellation of contract. That can be very problematic because the contract is very clear. You cannot send a cancellation until after first giving a notice to perform and the time allowed in the notice to perform to have lapsed. So send the notice to perform by itself, or the demand to close escrow by itself. And then when the other party doesn't act on that notice or that demand, then you follow up with a cancellation of contract. What agents do, and I can appreciate it, you're busy, you got a lot on your mind, you got a lot of balls in the air, you're juggling. So you want to sort of get everything cleaned up by just sending over that notice to perform. And if you're not going to perform, let's just cancel and move on with our lives. So you generate both, shoot them both off. You've created a problem for yourself. Don't do that. So do it sequentially. Take the time. All right. Now, so the notices, of course, I referenced them, the notice of buyer to perform, or a notice of seller to perform, or a demand to close escrow. So after those are sent and the time has lapsed that are on those notices or that were agreed to, and they have to match, I'll talk about that in a minute, then you follow up with a cancellation if that's the choice of your principal, of your client. Okay, so the notice to buyer to perform, I talked about that in some detail on the COP class, but I talked about it basically relative to a COP. I'm not going to go into a lot of detail here, but just to point out a few things. Of course, the top identifies the property, the agreement, the property, the buyer, and the seller. And then the body of the notice to perform contains contingencies or contractual actions. Contingencies are all on the left. They're all listed, the ones that are listed in the contract. Contractual actions are on the right, and they're listed in the contract. These paragraph numbers are RPA paragraph numbers. And then if the buyer doesn't remove the contingencies or take the specified contractual actions within 2 days of receipt of this delivery, but not less than time specified in the agreement, the seller may cancel. Now, here's a little trick. I know RE/MAX United agents know this. There are a few agents out in the universe that we deal with that have learned this as well. As a buyer agent, I'm going to suggest you take advantage of this. As a seller's agent, I'm going to suggest you look out for this. What am I talking about? I'm talking about page 6 of the RPA. You can't do it when the notice to perform is being done, but when you create a contract as a buyer's agent, page 6, paragraph 14, time periods for removal of contingencies. 14E, notices to buyer and seller to perform. The boilerplate says 2 days after delivery to take the applicable action. So if I get a notice to perform today, day 1 is Tuesday, day 2 is Wednesday. I have until 11:59 p.m. Tuesday to remove my contingencies because the boilerplate says 2 days. Here's my recommendation. Put in 3. Now, Larry has shared with me, and he can chime in if he wants to reinforce this. He's told agents to put in as many as 4 and 5, and they've gotten away with it. It is rare a listing agent's going to catch this unless it's one of Remax United's listings. I had an agent one time tell me, a Fallbrook agent sent a contract and they modified it. They put 3 days in. The listing agent used to be with us for a few years. She was a broker. She went out on her own and formed her own little company, her and her husband. When our agent sent the RPA over, she countered the 3 days back to 2 with a little note. Nice try. I've been to Walt's classes too. So, if agents know about it, they're going to pick up on it. But let me tell you, most agents don't pay any attention to it. It's not in red with a circle around it on the RPA. I've memorized where it is because I have to teach this all the time. But sometimes I've had to look for it, and I'm the one that's telling people to do it. It's sort of buried there on page 6. That's a nice little change to the contract. Now, why does this work so often? I can tell you anecdotally, from my experience, notices to perform tend to go out toward the end of the week, not at the beginning. Everybody's feeling good on Monday. They just had a nice weekend and they got a lot of going on and kind of hectic. So they're not worried about notice to perform, but they will call that buyer and say, hey, you're supposed to send me a contingency. Oh, yeah. Let me talk to the buyer. Okay. Send me a removal of that loan contingency. Okay, I will. Tuesday, I don't get it. I don't pay attention. Wednesday morning, I call up. Hey, I don't have that yet. Oh, yeah. Well, we're still waiting. Oh, no, you're not. I'm tired of this. You give a notice to perform on Wednesday. Day 1 is Thursday. Day 2 is Friday. If you don't modify this, you have until 11:59 p.m. Friday night. Wouldn't you like to have 2 or 3 extra days? Put a 3 here. Notice to perform comes out on a Wednesday. Day 1 is Thursday. Day 2 is Friday. The last day cannot be a weekend or holiday. Day 3 will be the end of the day, Monday, or even Tuesday if Monday's a holiday. So that's a nice little thing to be aware of. Okay, notice the seller to perform, actually very similar to the notice of buyer to perform. The top identifies the contract, the date of the contract, the property, and the buyer and the seller. The contractual items are on the top. Paragraph 1, there's several things by the seller is contractually obligated to do, and if they haven't done it, you can give the seller a notice to perform. And the contingencies far less because there's not many contingencies in a RPA that favor the seller. So, but there are a couple, so contingencies there. Well, as a matter of fact, they only exist if there's an SPRP. The only contingency in the boilerplate for a seller in the RPA is the contingency that the buyer must agree to take over a solar panel lease. If the buyer doesn't agree to do it, the seller has the right to cancel the contract. That is the only boilerplate contingency in the RPA. So sellers don't have a lot of reasons to get out of a contract. Buyers have a lot more, of course. Now, of course, if the seller doesn't take the applicable action, then the buyer may cancel. Okay. Demand to close escrow. By the way, let me back up and make one comment. If you get a notice to perform and they change the contract agreed to terms, that notice to perform is ineffective. Now, I would sort of figure you want to try to perform by whenever date you're supposed to perform. But if we need to argue it, I have successfully argued. I don't know that it's been the court, but attorneys have agreed with me, our attorney, car attorneys, and sometimes the opposing attorney have agreed with me that a notice to perform, even if we didn't change the 3 to 2, but the notice to perform said 1 day. No, the contract says 2. And so that's not an effective notice. So, we're not going to abide by it. You got to send an effective notice. I wouldn't point that out until a couple of days lapses. And then when they complain or they threaten to cancel, well, you haven't sent me an effective notice. That's the argument I'd make. Don't rely on that. It's not foolproof, but I've won more often than not. The days on a notice to perform must conform to the days in the agreement or longer. I've actually had in situations where the seller has said, look, they're supposed to remove their contingencies by Wednesday. They only got 2 days. If I give them a notice today, they have to remove them by Wednesday. I'm going to give them till Friday. Okay, put that in a notice to perform, and you're allowed to do that. You can make it longer. You can't make it shorter. Okay, demand to close escrow. It's basically a similar form to the notice to perform. Never use a notice to perform, though, to compel closing. The 2 reasons. One is the notice to perform, if the buyer doesn't act on the notice to perform, the boilerplate in the notice to perform says the seller, especially if it's a contingency removal, the seller agrees to refund the deposit back to the buyer. Using the notice to perform to demand a closing could complicate the deposit. And the second is, again, a notice to perform to compel closing is not effective because the contract says you have to use a DCE, a demand to close escrow. So if they're not closing, you send them a demand to close, not a notice to perform. The top of the form, like we said, pretty simple. The seller hereby demands that the buyer close escrow within 3 days. That's the minimum time. Why? Because civil courts have never held an effective notice less than 3 days. Courts require reasonable notice be given to the other party before you cancel. And reasonable notice cannot be less than 3 days by action of all the lawsuits that have ever been filed. So CAR put that 3 days in. Or again, you can make it longer. You can add a couple of days. You can make it 4 days, 5 days, or a date. But that date and those 3 days can't be sooner than the agreed to closing. Okay, hope that's pretty clear. The buyer uses the bottom half of the form to compel the seller to close, and the same rules apply. It has to be a minimum of 3 days, or the date scheduled to close, whichever is later. It can't be earlier than 3 days or the scheduled close of escrow. And then a confirmation of receipt is there. Now, the cancellation. So they didn't perform. They didn't remove their contingencies. They didn't close like they're supposed to. Now you send the cancellation. And when you send the cancellation, again, the top of the form, identifying the document and the property and the buyer and the seller. Paragraph 1, the top half of the form, if you will, is the cancellation of the contract. Sometimes agents misunderstand this. This is not a request to cancel. Now, whether or not you can prevail, just because you want to cancel, a seller can say, we're canceling. And they sign. And they sign their seller signature and they come up with some reason. If that reason isn't a bona fide reason to cancel and the buyer fights the seller, the buyer may well win. So the fact that you cancel doesn't necessarily mean you prevail, but if you cancel correctly, pursuant especially to the terms listed here, you should prevail. And you are in fact canceling. You're not saying, hey, we want to cancel. Okay, so you list the reasons you cancel, excuse me, and you sign the document. Now, it's important, rule of thumb, Never give a specific reason for canceling. Give the paragraph in the contract that allows you to cancel. So you don't list the reasons here. You simply list paragraph, it might be paragraph 12 or paragraph 14 or whatever, pursuant to that paragraph, you're canceling. You're obligated to act in good faith, but there is no contractual requirement for you to share. You don't like the traffic in front of the house. You don't need to say that. First of all, the courts won't force you to buy the house, and they won't tell you, oh, that traffic's not bad, you're being too picky. They're never going to say that. But it's just bad practice to give the reason. Sometimes the reasons can be cured, and now you got a problem. So you give the paragraph that allows you to cancel. And then the canceling party signs the document. My pet peeve is the canceling party clicks both. Now, both works when the buyer says, look, I can't get the loan, and the seller says, that's okay, I've got a backup offer. I'm fine with that. You want to cancel? No, that's okay. I'll give you a deposit back. Will you sign a cancellation quickly? Because I want to get this backup offer going. Well, now you could check both, but the buyer wants to cancel and the seller doesn't want the buyer to cancel. The seller might agree you have the right to cancel, but they don't want you to cancel. Both is not appropriate. Likewise, the seller wants to cancel. The buyer says you can't cancel, but the seller says both of us want to cancel. That's not true reflection of the situation. So be accurate. Who's requesting cancellation? Who's not requesting? I'm sorry, just violated my little point. It's not a request. Who is canceling? Either the buyer's canceling, seller's canceling, maybe in some cases both are canceling. Okay. The second half of the form under the heavy line is the release of deposit. Now, the release of deposit gives you several options. A, the seller authorizes the release of the buyer's deposit, less the buyer's fees. That would be checked, especially if the buyer hasn't removed his contingencies. You gave them a notice to perform. They did not remove their contingencies. You cancel and move on. Well, you need to give them back their deposit because that's what the contract says. Or the buyer authorizes the release of the buyer's deposit to the seller. The buyer recognizes he removed all his contingencies. Now he can't close for whatever reason. And, he's being honorable. I don't see that check too often, but sometimes the buyer does agree to remove the deposit. Both the buyer and the seller acknowledge the mutual cancellation of the agreement and escrow, but they're going to tell the escrow holder later what to do with that deposit. If you have a fight between the buyer and the seller over the deposit, as the buyer, you don't ever want to check C. You want the fact that the deposit's in escrow and that escrow is still open to complicate the seller a little bit so that you can, prevail, get your deposit back or force the seller to sell to you. If you're the seller and there's a dispute with the deposit, C can be a nice box to check because it will cleanly cancel the contract in escrow. And now you can resell the property with no problems. And the deposit is simply a matter to be resolved later. So C is a very seller-friendly box, not necessarily a buyer-friendly box. So sometimes that's a good compromise where the buyer and the seller can't agree with what to do with the deposit. I see this all the time. Because buyer's agents don't like this less buyer's fees and costs. Here's my suggestion. Confirm with escrow there are no fees and costs. If you're our buyer and you have escrow one as your escrow, I can guarantee you that we're not going to charge you a cancellation fee. I would be amazed if we did. I'm sure we'll resolve that if there was any such a situation. It had to be a very, very specific reason why. So you don't have to worry about your fees, the escrow cancellation fees. So you can check that box. There's a reason that checking D and putting all buyers' funds to be refunded the buyer is not a good idea. Why? because if A or B is checked, buyer and seller release each other from any claims whatsoever over this transaction. And it's done. They go away and they never bug each other again. Okay, great. If A and B, seller authorizes the buyer deposit to go back to the buyer, or the buyer authorizes the buyer's deposit to go to the seller. If those are checked, A and B, the parties release each other from any other liability. If C or D is checked, buyer and seller reserve the right and to go after each other. Basically, they have other opportunities to pursue this issue, even though they've canceled the contract. So C and D are not the best boxes to check from a relative, any other rights they might have towards each other. So that's especially D can be very problematic. Okay. Try to wrap it up here in a couple of minutes. How to handle backup offers, pretty straightforward. The backup offer addendum is when you have not got a signed cancellation of the contract, and I would argue the escrow as well. Signing the cancellation and the escrow not canceled is kind of problematic. So when you don't have a clean cancellation and you want to move forward with a backup offer, you can accept another offer contingent upon the successful cancellation of a prior offer. And now, if the prior offer prevails, you can cleanly cancel this offer. But if you just accept an offer without a backup offer addendum, or at the very minimum, the language that says, the second offer is accepted contingent upon the successful cancellation, or the sale of the property is contingent upon the successful cancellation of a prior offer, you could have sold the property twice. Believe it or not, that comes up more than I like, than Kenny or Cheyenne like. Agents just sometimes think they got a cancellation in hand. They think the document wasn't signed, the RPA wasn't signed or something like that. And so that we don't have an agreement anyway. To their chagrin, they find out, yeah, you do. And then we have to try to, do our best to wiggle out of it. So don't put yourself in that position. If you're accepting a backup offer, and by the way, you can accept as many backup offers as you want at any time. Just make sure you use backup offer addendums and put that in the counter. Now, backup offers should be numbered. Why? Because that tells you, if you have more than one, who's in line next. So as a buyer's agent, you want to see number one here. If that's a blank, and somebody comes along with a better offer than your backup offer, you're going to be in the second backup position. That better offer is going to be moved toward the first one. The date of these signatures doesn't count. This number needs to be there. So especially buyer's agents, make sure you get a 1 in there. And if it's not a 1, they say, no, sorry, there's somebody in front of you. It'll be a 2. Well, you should know that. Your chances of getting it with being position 1 might be 50-50, might be less, might be more. If you're in position 2, your chances are a whole lot less. So get that number in there. Okay. And then the buyer's deposit, the default is the deposit will go in 3 days after we receive cancellation of the prior offer. The same with time periods. They will start after we receive copies of cancellations of the prior offer. If you check the box, they will start immediately. They'll be handled per the RPA. Okay. And then, of course, the bottom of the form is notice of cancellation of prior contract. You can use this form to notify the second buyer that the first buyer has, in fact, canceled, and we can move forward with your transaction. That completes our class today. Ran just a little over, a lot of material. Hope that it clarified a few questions for you, gave you a few tips on how to be careful in dealing with your transactions. I'll open it up to any questions before we close.
Walt.
Yes.
A quick point of clarification. This comes up a lot. This question comes up a lot. Page 9 of the RPA, the contract is signed. The contract has technically expired because the seller has not responded. And now the seller generates a counteroffer the day after the expiration of the offer. Could you explain the implications of that?
Right. The cleanest way to do it is, especially if you're generating the counteroffer after the expiration and you're aware of it. So the cleanest way to do it is to make that part of your counter. Buyer agrees to extend the offer and then put it past the date that you're writing the counteroffer. Give yourself a day or two to get the paperwork done. That's the cleanest way to do it. You can do an addendum if you discover afterwards right away that, gee, the buyer seller agree that the expiration is null and void, and they both agree to the contract. That can be done immediately. The risk you take is if 2 days later nobody's done anything, the seller especially hasn't done anything, and now the seller realizes, oh, wait a minute, we counted you after the expiration and I have a better offer. You don't have a deal. Now, here's the good news. If that discovery that you don't have a deal happened 2 weeks into the escrow, you got a deal. There is a legal concept which is very enforceable, and that is when the parties act like they have a contract, they have a contract, especially if there's underlying, well, not especially, in real estate, you have to have an underlying paper contract signed by the parties. But even though the expiration technically says we don't really have a contract because it expired when we signed this, but escrow was opened, seller maybe contacted escrow, seller met with the appraiser, buyer performed the physical inspection, seller's negotiating the repairs. Now the seller says, wait a minute, this offer was accepted after the expiration. That won't fly because the parties acted like they had a contract, and that's very enforceable. So you are protected, but the best way is to address it early, immediately, because you do have that window of time, maybe the first few days, where you could think you have a deal and the seller could figure out, or vice versa. A buyer's going to get out of it anyway. They got all their contingencies. It's the seller you want to lock in. If the seller figures out, wait a minute, this was executed a day after the expiration, and now 2 days later, I've got a better offer, I'm going to say, nope, sorry, we don't have a deal. You don't, technically.
Second half of that question?
Yes.
You knew there was
answer the first half.
You knew there was a second half, Walt.
Okay.
I hate to say it, but listing agents can get lazy, and in this market, they'll generate a counteroffer and send it back without signing the RPA. They'll just send out the counteroffer. We know that happens all the time. It gets finally negotiated and agreed to, and now you have an accepted counteroffer. A day later, the RPA comes in, and it's signed and dated after they signed the counteroffer.
If I'm following you right, you still have a contract.
Exactly.
Yeah. And technically, that brings up a good issue. It wasn't part of your question, but it is sort of part of your question. Never backdate a signature. The date next to the signature means, the only thing it really means is that's the date the person picked up the pen and wrote their signature on it. It doesn't signify much else if there are other things involved. If you backdate a signature, and of course, if your client backdates something, they're holding on to this document and they backdate it, they shouldn't, but you don't know about it. They don't tell you. That's between them and their own conscience and their own problem. But here's the problem that we get into. Agents tell their clients to backdate. That's the worst thing you can do, because when there's a dispute later, they're going to say, well, when did you sign this? Well, I backdated it. Why? Because my agent told me to. Now you've established yourself as a liar, as someone who's, perpetrating a fraud or suggesting a fraud be created. So never suggest a backdate. Once the counter is signed by both parties, it doesn't matter really the dates on the RPA, because you accepted it relative to the dates on the counter, and that's why I pointed out that acceptance. The one thing you bring up another issue that I know it's a pain in the neck, but this, I thought you were going to go with this, but I guarantee you Larry's going to be nodding, and Mary will be too. You get the counter back. I'm sorry, you get the offer back 4 days later, and you discover liquidated damages wasn't initialed, and you didn't know it. Or arbitration wasn't initialed and you didn't know it. And so now you don't have it. You got a contract. You definitely have a contract, because the contract says you have a contract, but you don't have that because there's no initials there, and it was never addressed. So you should, I know it's a pain in the neck, but with digital copies, it's pretty simple. You should get a copy of the offer with the counter. You should request it. And then you want to look for, the signatures are nice, but the initials on the liquidated damages and the arbitration are essential if that's what your client wants. Great questions, Larry. Any other questions?
Walt, I have a really quick question. As offers are coming in, several times I have a buyer offer. I'm the listing agent that comes in, and then the buyer decides, oh no, we want to increase our offer. Now we know that there's 12 offers, and when we submitted ours, there was only 3. So we want to increase our offer. The buyer's agent is just sending a new first page to go with that offer. What's your comments?
Yeah. That's a very horrible practice.
I know.
All the time. They don't do it. They say to the clients all the time, just replace page 1. And they do that not immediately like yours. At least I could say it's immediate. They do it 3 weeks into the escrow. Well, wait a minute. There's a page 1 out there already signed, and who knows, who's all got copies of it. So yeah, replacing an executed document once it's been submitted. Now they can replace it before they send it to you, but once they send it to you,
that's what I'm saying. They've sent it to me.
Now they want to replace it.
Responded, right? Nobody signed, other than the buyer signed.
My recommendation is that they send an addendum to their thing, and purchase price shall be, and they change the price on the addendum. If you haven't executed page 1, it's not the worst thing in the world that they replace it. Oh, I sent you the wrong page 1. Please, but what I would suggest they do is send the new page 1 with the entire contract. Now you can throw out the first one, and you're not the one, injecting a new page 1 on top of the other 10 pages. So I guess thinking about it, if they were to call you and say, we want to replace page 1, your seller hasn't executed it, you could say, just send me the new document and write your new page 1 if you want. It's okay with me, but send me a new document, and I'm going to go with the new one. Well, there was a lot to cover. I appreciate you hanging in there with us.